from you. Is there anything you'd like to add?
No.
Okay. I think it's appropriate at this time due to the circumstances to grant the motion. We'll be having your parenting time at Journeys and professionally supervised until the time limits necessary, and then we'll make sure everything's safe and we'll move on again.
Okay.
All right, Miss Van Dyken,
I have
I
an
can,
order already, Your Honor. I'll send
all
it
right,
over to your
send
clerk.
it over and we will get it signed by DocuSign. That way it can start. Miss Kraus, when are you going to be released?
I'm supposed to be released May 28th of this year.
All right, good luck to both of you.
Okay, thank you so much.
Take care of
Thank you.
yourselves. All right.
Thank you.
No, thank you. Thank you for such a reasonable request, sir, under these circumstances.
Yeah.
Okay, next. Okay, well, this is a pro forma motion because his motion is to enter the front of the court recommendation, which the judge entered on April 16th.
Okay, so
It's like, I'm sure this is a language barrier problem. But yeah, his motion was, nobody objected, so his motion was unnecessary.
okay, so are you okay?
It was just me bringing the interpreter and him in.
Yeah, yeah. And then
Okay.
we'll tell her when she gets in because basically there's no ruling this morning. It's already been done. I'll just try to explain to them that their order.
Okay. And he doesn't need the interpreter. It was for her, unfortunately, though.
Okay.
So if
Oh,
she comes in later, I just
we'll
thought of
see.
it as I brought them in.
Yeah. Mr. Mohammed, did you connect, sir? This is your motion for a show cause hearing. Well, we're here in the matter of Ensing versus Schmidt, case number 22-03489 DC. What's going on, ma'am?
Yes, so I'm covering for Miss Smulders today. We filed this motion because there is an order that when the parties communicate on Our Family Wizard, it's supposed to be strictly about the child. And
Right.
there's been some stuff being said about my client specifically that I think falls outside of the purview of being about the child. Some derogatory things like that. There was another one after we filed of him calling her an evil manipulator.
Isn't
That
this
stuff
going,
is,
isn't this stuff going through My Family Wizard or something?
yes.
Okay.
It needs to stop, Your Honor. Like it's outside of the scope of what they should be communicating about. There's no reason for that. If they have issues, they have
Yeah.
issues, but it should be about the child strictly. And
Right.
so that kind of behavior just needs to stop, Your Honor.
Sir, what's your response? I've read your response. What do you have to add to it for the record?
Honestly, I think that Marissa's frustrated that I'm finally making headway, getting some more time with my child. I finally got vacation time. I think she's just filing petty litigation, and I don't think this is.
Well, I don't know if there's enough to hold you in contempt here, but there's enough that I can look at you and say, knock it off. I mean, these communications don't have to be
Okay.
at what they are. You need to stop. My problem, Ms. Korndike, is a lot of these communications are within parenting time requests and confrontations, but this is not for confrontation, Mr. Ensing. This is for communication.
I understand.
And you are becoming somewhat confrontational. And I realize it's in the context of you asking for parenting time. But there is no necessity for name calling or, just being blatantly obnoxious. But, just because he's being a jerk on these is not enough at this point for a show call, for a contempt hearing. But it is enough for a warning to say, Mr. Ensing, when you're talking to her, you're talking to the mother of your child. Talk to her as such. Ma'am, vice versa. You're talking to the father of your child. And you're right, you should be upset about these. This is unnecessary, Mr. Ensing. And no, this motion was appropriate so that you can come into court and be told, grow up. Okay? So to that extent, I am enforcing the inherent rights portion of the judgment and the statute, which means neither one of you is supposed to disparage each other. That is inherently illegal. It's part of the statutes of the state of Michigan. So when you get that stupid, luckily, I don't think you crossed a line. I've seen a lot worse, Ms. Korndike, forgive me, in comparison. But it's appropriate to bring it in to say, admonish you and say, don't do this. Because you're going to be coming back here, and the next time it may be enough for contempt, especially now that I've warned you. Okay?
Understood.
Make your requests. If there's a no, either bring it back to court if necessary or work through it. If there's a yes, great. I mean, I didn't choose the parents here. Both of you did. You're going to be living with each other for a long time, hopefully. Okay? So Ms. Korndike, as to show cause, I'm denying the contempt, but I am saying that this was appropriate for a warning shot. Okay?
Okay, yes,
Mr.
I'll draft
Ensing?
an order.
Okay, no problem. Good luck,
Thank you.
everybody. Thank you.
Thank you.
I always love it when they get close to the edge and just don't put their toe over the line, but just put their toe right on the line. Like, okay, guys, stop being in 5th grade. Next. Ms. Myers, did you
Yes.
file a response here?
We did not file a response. I was just
Okay.
retained. I did.
Okay.
Yeah.
All right, no problem. I just wanted to know. I just wanted to make sure.
Yeah.
Yeah. All right. So we are here in the matter of Jameson versus Busuk, case number 23-06095 DM. Sir, this is your motion. What is going on with your income?
So actually changed jobs. I switched from another tree company that is
But you're
basically
you're still doing tree work, correct?
Yes, sir.
Why did you switch the jobs?
The winter work slowed and it looked like he was going to go out of business, so I took up other opportunities.
And it's a little bit less pay, but not much less pay, correct?
Yeah, it's $3 less an hour.
Ms. Myers, any input on this? I mean, I've always had problems with lawn services because they do go in and out of business, and sometimes if you see the handwriting on the wall, normally if somebody leaves their job through no fault of their own, or through fault of their own, I kind of hold them to the old income. The problem is this is not one of those jobs that is continuous or steady for the most part, at least in my experience. So
It's my understanding that he voluntarily,
I understand. Yeah, voluntarily, but if he's got evidence that, possibly he was, he wasn't getting any work, that doesn't help.
No, that's not the case. Actually, he just moved on to a different job. The company
Right.
that he worked for is still in business. It's been in business for quite a while. So it was more an issue of he recently got called into court because he's 10 grand or whatever behind,
Right.
and now he all of a sudden has
Well,
a new job.
considering if you're saying that he was steady there and he's 10 grand in behind, my question would be this, because we take the money from the employer, not from the parties, which means if there's a steady income, why would there be an arrearage?
It's my understanding that there was an issue with the income withholding order, and
Okay.
my client did bring it to the attention, but just so the court also is aware, Mr. Jameson has been very vocal about the fact that my client would not get money. And there were some
Well,
discussions between him and the employer.
Right. Okay.
I haven't seen an income withholding order at all, even go out to it.
You won't. The income withholding orders go only to the employer because of because of the information contained within them. It's kind of personal, and that's why the court never sees an income withholding order either.
So
we don't need it. This was just recently entered. That's why I'm trying to. Well, actually, it's been almost 2 years, correct?
Correct. 2023. When was your?
Yeah, 2023. It was fall of 2023. Sir, how long did you work at that place?
I would say about 3 years. And in January, he told us that we were going to be laid off until March. And that's when I looked for another job.
Do you have that in writing?
Yeah, I can probably find a text from.
Then I will need to see that.
Yes, sir.
And it's going to hinge on, because if he was told that they were going to be closing down for 3 months, that would give him no income, ma'am, and searching for another job would have been appropriate. But like I said, that's why my first question is, what's going on with your job?
Yes, sir.
So I expect you to get to me, and Ms. Myers, have you been on this case before?
I have, Your
Yeah,
Honor. I
you have.
represented-
So,
yeah.
sir, you have her contact information. I suggest you get her a copy of that text.
Will
We're
do.
going to set this for a settlement conference in the next 2 weeks to determine, that way I can look at it, Ms. Myers can look at it, we can sit down, and if there's a justification here, I'm willing to give some leeway. Because let's face it, in another 12 months, he can probably ask for a child support review one way or the other. But the idea is to make sure that we get that money flowing. So bottom line, sir, regardless, you need to contact the front of the court with your job change to inform them where to send the new income withholding order to, so you don't become more and more in arrears.
There,
if you-
and
Yeah,
this week we did put in a withholding.
okay, to your new
So the
employer?
fir- Yes, sir. The first withholding came out this week.
Good. In that case, then the money should start flowing, Ms. Myers, and then we'll find out if it's appropriate to adjust. Because I also had a question as to, I believe she was held at 0 income. Why was that? Is your client
Actually, I think
disabled?
she was imputed. She provides all the childcare, Your Honor, so
Okay.
that Mr. Jameson, it's the way that their marriage was set up as well, so that Mr. Jameson can work.
Right.
So he can work anytime he wants, which is why I was also going to bring up the fact that he works significant amount of overtime as well.
Understood.
So, yeah. So there's
That's
no.
that's
child-
that's why I'm questioning this. I'm not making this an automatic.
Right, I
know.
understand. Thank you.
Yeah, no, she was held at 0 income. That's
And
also
I think it's because the decision was either 0 income and then we do something with childcare or we impute her. Because if she goes to work, obviously childcare is going to be much more expensive. They have 4 children, 4 young children.
understood, but looks like this was part of the agreement of the parties back then. Alrighty.
It was.
But I will look at this because neither party may like what's going to happen at the new review, because they changed the guidelines again, so that it might not work for either party, and I'd rather not hurt either party either. But
There is
I
one
also
more
want to get it.
thing.
I also want to get it correct, because let's face it, like I said, when we find it incorrect, we find it imbalanced, and then nobody gets any money. It just winds up chasing tails, and that's not worth it. So what's your question, Ms. Myers?
One other thing, so we're gonna come before the court in September because my client is currently pregnant and due. So there would be a change in September, either way.
Oh, okay. So it may be that we have to look at it now because of his change, if it's an appropriate change, and we'll have to look at it again in September when there is another change. Okay, but her birth, if she's held at 0 income, ain't gonna change anything. So unless you want her imputed and that income then offset by their new child, that's fine. But if she's at 0 and stays at 0, birth of a new child won't change the mathematics here.
Right.
You have to have income to deduct from. And since the party set this up at her at 0, you don't have a change of circumstance from that one.
Yeah, we're
You
just.
could
I'm just trying
ask
to get
for
my
it, but be
client-
careful again what you ask for.
Right. I'm just trying to get my client some money because there is such a
Well-
huge arrearage. I think there might actually be a warrant too that might be.
That's why I'm
being
warning him,
issued.
and that's why I'm going to look at
Mhm.
this a little bit more closely to make sure that
Thank
we
you.
get it right.
Thank you.
Okay. Again, that's what we find out. That happens if you set child support incorrectly. Now, again, why there's been a kind of continuous employer up till a couple months ago, $10,000 should not have happened that easily. Is it that there was a back order to it too? No? Okay, then
He just wasn't paying, and
again,
again.
he doesn't pay. Income withholding
Right.
orders pay. That's
I
why, and that's why I asked
understand.
him. He's been employed there since before the inception of this. There should have never been an arrears, so something happened with a paperwork screw up somewhere.
I understand, but I think there's some nefarious things going on behind the scenes. Whether or not Nick provided the actual information in regards to his employer, whether or not he had a deal with the employer not to pay. And my client
Well,
has been on top of it,
the employer would not like that, because there is case law out of Kent
Right.
County where they took an employer to task. The employer not
Yep.
only had to regurgitate all the funds, the employer had to pay fines and penalties, and it was
Right,
Fifth Third, and it was not pretty.
right.
We're talking into the millions.
Right, and my client did contact her worker to try and sort
Okay.
that out. It's just never been sorted out.
Okay, well, we'll see if we can sort it out better this time. And
Perfect.
hopefully we've
Thank
got an
you.
income, well, hopefully we'll know if there's an income withholding order in place and then she's getting her money from the new employer. And this
There's
job
also
is good.
supposed to be.
This job, Mr. Jameson, is continuous? No?
Yes, sir. Yes, sir.
Okay. Yes, Ms. Myers?
There was supposed to be, last time the parties were in court only a few weeks ago, maybe a month ago, February, 2 months
Okay.
now. Mr. Jameson had indicated that he had filed his tax return, so had told the court at that time on the show cause that there would be money forthcoming in that regard. It's my understanding that he's withholding filing his return.
Well, that's between him and the federal government. That also has consequences and penalties. So, yeah, normally if there's an arrearage, if it's my understanding, the IRS sends out the letters in August to prepare for the end of the year, and then they set up the confiscation of any type of tax return. So we'll see what happens.
Can I
Yes,
ask-
sir. Yeah, Mr. Jamerson.
So I had texted her telling her that I had filed my taxes, which I did. And then she told me that she had claimed the other two, which I don't really know how taxes work. So I was assuming that she got the money for the two per the court agreement.
I don't know.
So, and the only reason I go
Now,
through
if you're following, that doesn't go against your child support. That's her taxes, just as your taxes are your taxes. Okay. All right. So we'll see each other again shortly. My clerk will be contacting you to set up a short, quick, and I suggest you get that any type of paperwork to Ms. Myers and myself so that we may have it to review for the settlement conference, sir. All right.
Thank you, sir.
Good luck, everybody. Take care.
Thank you.
Thank you.
All righty, so we are here in the matter of Brewer versus Brewer, case number 23-09946DM. I will note that the plaintiff, the moving party, is here with her attorney. The defendant is not present. The judgment is not clear who's living in the house.
He is.
Right
Your
now, he is.
Okay, so neither, because
Honor. And not paying a dime.
and not
for the-
paying a dime for it. Yes.
No.
And it's the intent that neither party live there because it's supposed to be sold.
Correct. And we've had conversations with the real estate agent that says he needs to be out.
Yeah, and he's going to be given 30 days,
30?
end of May.
Okay.
He was given
I-
notice of this in April, so he's already been noticed that he's going to be removed from the home
So by
because
May 31st?
first, yeah, he's got to be out of the house. I'm treating it more like an eviction. He's been given notice. He's been received the paperwork of basically these are eviction paperwork, and he is becoming an obstruction to the sale of this house, especially since he gets to live there rent free and not having to pay. I think he at least pays utilities, right?
He does not.
He doesn't even
I'm
pay that.
filing a motion for her to recoup all of them.
Yeah, obviously. Yeah.
Yep.
Yeah. Okay, because I'm reading this and I'm like, it doesn't say who gets it. So, but in any event, I think you guys anticipated a quick sale.
Yes.
Yeah, and that's not happening. So yes, he shall be removed from the house on May 31st, and you may take possession so that you may get it sold.
Okay.
That's in accordance with the judgment of divorce. It's one of the contingencies and available remedies within the judgment. So we will follow the judgment of divorce that you guys signed. We'll try and make the initial intent of getting it sold quickly done.
Thank you.
Have a good morning.
You too. Thank you.
Motion granted. Take care. All right. All right. We are here in the matter of Wilkes versus Thompson, case number 23-11306DP. I've read the motion. I will note that Alaya is not here. It's now 9:17. This matter was set for hearing at 8:30. I'm granting the motion to enforce the parenting time. I am also granting an actual hearing, and I'm going to make it before the judge. What I need from you, sir, is the exact dates that were missed.
We have those,
Okay.
Your Honor. He hasn't seen his
Okay.
child since April 19th,
Right.
or April
Yes.
9th. I'm sorry, he has missed 14 overnights.
Yeah.
I would also like an order that he can immediately go retrieve the child.
Yes. Yes, he can. To enforce his parenting time only, he'll have to return the child. So he gets his days for now. What I'm reserving is makeup time because I need to know the exact days that were missed. And I'm setting this in front of the judge because if she doesn't show there, a bench warrant will be issued for her arrest.
I will do the order, Your Honor.
He can do that quicker than I can. I have a 21-day appeal period on my arrest warrant, on my bench warrants.
Correct.
So it's like I'd rather get this done quickly, especially since it's been going on for over a month.
And it would be my understanding that this would be her normal parenting time weekend, so he will be enforcing his parenting time come Monday.
Come Monday, yes, that'll give time for the order to set.
Thank you.
I will sign that today if you send it by DocuSign. Good luck, Mr. Thompson. I look
Thank
forward
you.
to you seeing your children. Have a good day.
Thank you, man. Yep, you too.
You can say police may assist if available on
I was
that
gonna
order.
have it. Thank you.
Yeah. Yeah, they don't normally, but if it's in the order, they may help. And make sure you have a copy of your parenting time order, sir, with you.
Okay.
Okay. All righty. Take care. Good luck.
Thank you.
Motion granted. Okay, next. We do not have Mr. Jernigan here, correct?
No kidding.
That's what I'm thinking. I'd assumed that he was here. Ms. LeVay?
Assumed he was with Mr. Curcio, I guess.
Oh, no.
No, I
Mr.
represent Miss Parker.
Oh, I apologize.
Yeah,
I
yeah.
apologize.
I was gonna say, no,
No,
he,
he was here.
Oh.
He changed his name on me. Sorry.
okay.
I put his last name in, then he took it off. Okay.
Oh,
sorry.
okay. All right. So that's, yeah. Well, at least he came in as, named in an iPhone, because normally they just come in as an iPhone. We don't know who the heck they are. All righty. Mr. Jernigan, did you connect, sir? You have to unmute.
Yep.
All righty. I guess I have some questions on this one. We are here in the matter of Jernigan versus Parker. Case number 21-02535DC. Mr. Jernigan, this is your motion, but my problem is this. This case was filed in 2021.
Yes.
Correct? All right. There was a temporary order issued. The front of the court was ordered to do an evaluation. That evaluation, parties did not cooperate, and they terminated their evaluation. This case is dead. There was no final order. A final order is supposed to be entered into these cases after 238 days. We give a few months leeway, but not a few years. This case is dismissed. You have to file a new case if you want one.
I thought that's what I did when I went down and filed. Maybe
Nope. No, you need to file a new case. And I'm going to put an order in here to make sure that this case is noted to be dismissed. Okay?
that's probably was a
No, that's okay. I didn't notice it till I was looking at the file more closely.
All right.
And I'm like, there were only 4 events. The motion for the temporary order, and then motion for parenting time now. And it's like, there's no final order in this case at all. Somehow it's been floating out there for a few years, but it really is a dead case.
Okay.
I think the front of the court order might have mucked it up a little bit because their
Yeah.
order indicated that it was a final order of the court.
Right.
And it was a final order that said nothing.
Right. Yeah. I think that's what happened. Yeah.
Yeah. So this case is dismissed. You have to start a new case now. Mr. Curcio, any questions? I read your response, and after I looked at it, I'm like, this is unusual. I don't think I've ever seen a case like this. Normally they actually put in dismissal paperwork within a year.
Our position this morning was really just if the court was going to construe that order as a final order, then we'd have to do some jump through some procedural hoops this morning, but I think dismissal is appropriate.
Yeah, technically, I think it's been dismissed. It's just been hanging out there and nobody put in an official order because nobody noticed. So we'll get that official order in, and then that you can refile a case, sir. All right. Or ma'am, Ms. Parker, you may file a case as well. It's up to either one of you.
Yeah, I'll get with my lawyer.
Yeah. Mr. Curcio, you filed an answer. Thank you. Mr. Jernigan, thank you. I'm sorry I couldn't help you, but there's nothing I can do about it.
Thank
All right.
you.
Take care.
You too. Thank you.
I think that happened about the same time we were flipping judges because of elections. So I think that it fell through the cracks because normally the judge would have had to explain to the Supreme Court why that case lasted over a year, because they have to explain them if they're not closed. So again, slipped through more than one crack. All right. Next. Mr. Churchill, the moving party, is not here. So I'm assuming you read the... So anything you need? Because I mean, his request is kind of standard, but the problem is he's not here, which means I'm going to deny it unless you agree with it.
So I don't really agree with it. I haven't
Okay.
even received
That's all
anything.
that's all I needed.
Thank you.
You know, normally, so that you understand, there is no specific parenting time ordered in this. It's by agreement of the parties. His
Okay.
request is for specific parenting time. The court must grant that,
Okay.
but he's not here to ask for it.
Okay. And I do have a question.
Sure.
So we did have court, I want to say in 2023.
Right.
He's supposed to have supervised visits through Journeys. And he has not exercised any of those.
That's the way it stays until further order.
Okay.
So keep records of when he hasn't done it.
Absolutely. Oh, absolutely.
Okay. All righty. Good luck. And I'm more than willing to help the child know that each of you, but I can't help people that don't show up.
I am with you on 100%.
All righty. Good luck, ma'am. So I'm going to deny it since he didn't show.
All right. Thank you.
Talk to you later. Bye.
Bye.
I don't understand that. Like, more than happy to help this child get to know you, but you got to be here. All right. Next, we're here in the matter of Martez versus Hawkins, case number 25-00208DS. Sir, this is your motion. What do you care to add to it?
What do you mean by that?
That's okay. Ma'am, you received the motion, correct?
I did.
And any response? Because I didn't get a response from you.
I did submit a response at the
Okay.
county clerk office.
Oh, I'm afraid the court didn't receive it, but that's okay. So that I can explain this to you, there is no parenting time that's ordered in this other than by agreement of the parties.
Okay.
As there is no specific parenting time, either party may request a specific parenting time schedule at any time if there isn't one. So it's kind of an automatic. I will be sending this to the front of the court for a parenting time review. Your response will be forwarded to the front of the court. So will your motion, Mr. Hawkins, so that they have some idea of kind of where to start. After that, they're going to meet with both of you. What you're really going to need to have available is your schedules. So your work schedules, your schedules for what if you have any sports or anything. I've had people that are in bands that have band practice on certain nights. So they need to know when you're available, basically. And they need to know when what the child schedule is, so that they know when the child is available. The child has the right to know both of you. So as long as it can be done safely, we are going to be getting parenting time going. But the two of you need to sit down because I don't know what your schedules are. I don't know what the child's schedule is. So you're going to sit down with the front of the court and they're going to make a recommendation. The judge waived the fees in this case, so I will send it to the front of the court, who will be contacting you in the next couple of weeks to sit down with you and discuss this more in depth. An hour.
Okay.
Can take an hour to 3 hours. It depends on how long, what the issues are. All right.
Right.
So be prepared to come to the table and maybe offer some solutions about this. Okay.
So the determination of parenting time will be discussed with friends of court as
Right.
opposed to this hearing here.
Well, again, I don't know what your work schedules are. Am I going to give him an evening and I find out he works second shift? That doesn't help.
Right.
So I don't know when either of you are available. That's the problem. A lot of people come in and they ask for these things and they give me you gave me more than 3 sentences, but I have a few that just come in but it's basically, there is no parenting time. The parties can't seem to agree to parenting time. That's kind of an automatic. If there was already parenting time ordered, we would have a different discussion. But somebody needs to sit down with you and spend that time. You don't want me making a decision in 5 minutes for when I don't know anything about the child or either one of you. Nothing like that is in the file. Okay. All righty. And the fees are waived. Mr. Hawkins, any questions?
No, sir.
Okay, so they'll be contacting you shortly. Good luck. Take care.
Thank you.
So,
Okay, next. We are here in the matter of Palazzolo versus Palazzolo, case number 23-10327DM. Ms. Van Dyken, you are here on behalf of Mr. Reens, who filed this motion. What do you have to add to this motion, ma'am?
Your Honor, simply that I believe that he meets the threshold for Shade be right with regard to the parenting time. Mr. Palazzolo has changed his work completely in order to be available. It benefits not only him, I admit that, but it also benefits the child, not having to be in daycare or having an au pair or a nanny, transportation. And it also benefits Miss Palazzolo. Let's not forget that she is, I agree, the primary physical custodian, but she would want her child to have a better relationship and a long-standing relationship with the father. So I think the court should set this matter for an evidentiary hearing where it can hear the evidence with regard to the best interest factors and go from there. Thank you.
I guess let me set this up. So He changes his job, but he's doing the same type of work, correct?
Independent contracting, Your Honor, no longer.
But
under
he's,
the
yeah, the
guidance.
hours are different. There is nothing in the judgment that ties it to his parenting time to the job other than the fact that he might lose a weekend because he has to work that weekend. So, yeah, I'm afraid that looking at this, no, what's going to do the child better is if these parties stop the continuous litigation. It's getting ridiculous. There shouldn't be 4 files on a case that's only a year and a half old. This is absurd. So no, this judgment was just entered 6 months ago. We're going to finally let the ink dry on something in this case and let it solidify. And you might be putting words in Miss Palazzolo's mouth about, I'm sure she wants that relationship. She did. They negotiated this. He's got parenting time. That was already set. It was put in order. It was put in a judgment in October. So 6 months ago, we're done. No, we're going to let the ink dry on this and the litigation needs to stop. That will help the child. Yes, Mr. Quinn.
I don't have anything to add to the substance, seeing how the court, I think, has already ruled and denied the motion. Our only request would now be for attorney fees for having them bringing this motion.
Yeah, no, like I said, you guys got so many things in the works on this. No, not at this point. Again, you guys both need to land these helicopters and stop this litigation. Good luck.
Okay. I'll prepare the order, Your Honor.
Yeah, move on with your lives, please. Thank you.
Thank you.
Oh, Mr. Churchill just showed up. The one who failed to appear for his own motion.
Yeah, and that was set at 8:30, right?
That was set at 8:30, yes.
All right, go ahead and bring him in and I'll explain to him that I've already ruled.
All right.
He may object to my ruling.
Yep.
Mr. Churchill, if you could unmute, please.
Yes, sir.
Yeah, this hearing was set for 8:30. We already did this hearing. I denied it because you weren't present. So
I apologize.
That's okay. What you can do at this point is just, there's a 21-day objection period to anything I recommend. Therefore, you may object to what I did. And that might be a quicker route. Okay.
Okay. Was the hearing just adjourned then? Or
no, I
mean,
denied it. You didn't show
denied?
up. It was when you don't show up for your motion, we're going to deny it.
I totally understand.
The other side did show.
Okay. I
All right?
apologize for that.
That's-
I'm a foreman on construction site. It's been really hectic. So
Well,
I apologize.
I guess it was better than, you didn't lose too much to work. So good luck.
Yeah.
All right. But
Thank
yeah,
you.
you can object and move the case along if you need to. All right.
How would I go about doing that?
You can check with the Legal Assistance Center on the 5th floor of the courthouse
Okay.
once you receive the order.
Okay.
All right. All right. Good luck. Take care.
Thank you. You too.
I hate when that happens. That just means the parties have to take off more time and play back and forth. Don't like wasting their time either. All righty. Next.
Vandalier versus Valier.
We are here in the matter of Vandalier versus Vandalier, case number 14-093997DS. I have a note from the judge on here, but I think I'm going to move on anyway. The judge actually questioned pursuant to MCR 3.215 subsection E, subsection C3, D, subsection II. That he was wondering why this motion should even be heard this late. But in any event, I want to hear it because my question is, did everybody get the redlined version that was sent last night?
Yes, because I produced it.
I know you produced it. I'm asking the other attorney. Ms. Schultz, did you receive it?
I did.
Okay, that's going to be my order. That's it. The redlined version is pretty much what the transcript follows. And it does kind of fit into my intent. I allowed some leeway and some wiggle room in that thing, but that's because I want the counselor to make an evaluation. If the counselor thinks there should be something, the counselor can bring it up. The parties can disagree to ongoing, or we can have a Lombardo hearing on whether another counselor would be necessary. But we'll see. Okay, let's get the child in, get him through this grieving process. And again, if my problem is that every time I've ever had to order a specific counselor, you see the counselor squeeze through it and go, I'm not accepting the case because I'm not getting involved with the court. So that's why I'm very cautious about ordering or the court choosing. I thought I would help one time. I was about 2 months into this job and I thought, because I used to work in the psych field, I'll give a couple people a call, and everyone I called said no. Because it was the court calling, and I learned very quickly that, okay, the court shouldn't do this. We learn our lessons, and that's why sometimes I order things that people are like, why are you doing that? I'm like, trust me. I've been there, done that. No, you get your fingers burned a couple times and you're like, yeah, not doing that again. So, but I'm here to help if necessary. That way you guys have an opening for a scheduled settlement conference if necessary. But I wish the child
Okay.
well. Let's get him through this grief
Thank
counseling.
you.
Okay,
And I,
thank you, Your Honor.
Yes, Ms. Schultz.
May I, just for the record, I think, Ms. Vandelier's concerns really are just, the wormhole, right, that the court was talking about last time we met. And so I think her biggest concern at this point is just, allowing, the court, basically reserving the right to come back in, right? And resolve these issues.
And that's why if there's an argument between the two, I can automatically resolve it instead of having more motions filed and stuff. Because it may be that I look at it and go, no, this kid doesn't need to be. We don't need to drag the kid through the mud. Most of the time, my experience is the parties need counseling more than the kids do. In this case, though, because of the underlying grief, child does need counseling.
Okay.
So,
Thank you.
and, the loss, he's got a process. All right, take care. Good luck.
All right, thank you.
Thank you.
Bye-bye.
We are here in the matter of Massey versus Massey, case number 25-01127 DM. We are here to amend a temporary order. Ma'am, Ms. Pelto, I've read your request. Sir, what is your response to that request?
Your Honor, I would like this motion dismissed, just due to, there's a hearing on June 17th with, Judge DeLange.
Right.
I feel that I've abided by the court orders, and I have moved within my 100-mile radius.
Uh-huh. And you made it almost impossible. Do you guys each have a vehicle now?
I'm trying to remember what date it was, but last week.
So she was ordered to do a lot of the transportation, if not all of the transportation, and you moved so far away that now she's got to pay all this gas and all this other stuff, and you guys only have one vehicle that you can barely afford. That's why the judge set up the other thing in any event. So you choose to move away and have this kid spend over an hour in a car. You've had this great parenting time, both of you did. The judge worked it out, and then you choose to move so far away that you make it impossible.
No, Your Honor. May I say something, please, Your Honor?
Sure.
So what had happened was I was going to finish my lease out in Grand Rapids. And I told friend of the court that when we had our recommendation, when Miss Massey got locked up for her domestic violence, there was a no contact order that was put in place.
Right.
And I did depend on Miss Massey for a lot of things. And with that no contact order, it really made it hard. So I moved closer to family that would help me, with the kids while I was able to work. And also,
where is your job?
I work for PTS Refrigeration.
Okay, and where is that located? Where is your job? Or you drive around to houses and stuff?
It's located in Howell, Michigan, but I'm given a company van where I am dispatched from my house.
Okay, and is that the job you had when the initial parenting time was issued?
No, my hours got cut, so I had to change jobs. It was during that time. April 14th, I did update my address and my employment with friend of the court.
All right. What hearing is set for June 17th, Ms. Pelto? Is this going to be a divorce trial?
It's a settlement conference, Your Honor, at that point.
Okay. Yeah. Sir, I'm afraid you've made an impossible situation. I'm granting Ms. Pelto's motion, but it's a temporary order still. You guys still have the ability to maybe get this back to where it was. But for now, because of the impossibility and how far you moved, I know you moved within the 100 miles, but you still kind of pushed that one. So no, at this point in time, I'm going to have no choice because of the impossibility of making this occur, that for temporarily until you get to that settlement conference and a divorce trial, I'm going to have to grant Ms. Pelto's motion out of necessity for now. Okay?
Yes,
Good
Your
luck,
Honor.
everybody. Have a good morning.
Thank you, Your Honor.
Yeah, judge brought that one down to me too. So anyway, because he would have kept that, I believe, because he's got an ongoing issue and he's worked with them on orders that were very nicely done. And then all of a sudden, it's like, dude, really? All right, next. So we are here in the matter of Lavercombe versus Cop, case number 19-03869DS. Unusual situation, but we've had it before. That one of your jobs is, because they tend not to issue income withholding orders to every job. They try to hit it with the main one, but sometimes because your child support is based on the several jobs that you do, the main job was sometimes not going to be enough. They do have something that you can do, Mr. Cop. One is we're going to keep, I think the easiest thing to do is what I found over time is to leave the income withholding order, and any shortages you may pay. And I do have a email address for you to utilize. Let me find it. I've got to get on another screen. I'm sorry.
You're right.
Because I had the front of the court contact me because I said, procedurally, what's the easiest way to do this kind of stuff? Because I wanted to make it easy for you. So
Right. Yeah. And I was looking online too for a coupon for paying.
Right. And that's what they can set up
directly.
for. That's what they can set up for you, because you want it to go through the front of the court so you get credit for it. You can't do direct pay to Miss Lavercombe.
Right. Yeah.
Yeah. Because
Yeah, when I asked them,
otherwise
they
it's not
said
registered. Yeah.
They said I file a motion to get that instated.
Right. Yeah, you can also click on the, and I'm going to grant that that you can click on the IT service desk at kentcountymi.gov. And that's the front of the court place that will help you set up a ticket to then arrange for those payments.
Okay, and what was that again? I'm sorry.
IT service desk.
Okay.
At kentcountymi.gov. So I tried to find, it's been so long since I practiced. I was a divorce attorney for 10 years, and I would have known something like this because I would have dealt with it directly with my clients. But I've been doing this job so long. I'm like, so what's the newest procedure?
Yeah, absolutely.
And I need to, and I don't, I'm getting old. I don't always remember when the rubber meets the road. I just order the rubber.
Right.
You guys connect it to the road.
Yeah.
Okay. So they said that should be the easiest way.
Okay.
Okay.
So as far as the withholding on just one, and because some of the jobs I have, like I only work in December or in
and it may be that you have to, it may be that the income withholding orders are not going to work for you at all. Like I said, I noticed you have several jobs and they kind of, this one's during this season, that one's during that season. And so a lot of those income withholding orders may become moot. But yeah, the best thing I could do is say they're going to try and do the income withholding order and then just keep up with it and set up that ability to get a ticket to pay the remainder. Okay. Or all of it if necessary.
Yeah.
By the way, if there's an overpayment within 48 hours, they will send you a refund.
Yeah, that's what I want to try and avoid is because
because otherwise we got checks crossing back and forth. Yeah, they're not allowed to hold on to money that's not owed.
Understood.
So yeah, we're hitting that time of the year that everybody got their tax refunds confiscated, and then if they paid it up in the interim, the front of the court will be reissuing those checks back to them. So the transfer of money right now just, I think they did $80 million worth of stuff in Kent County last year. So we do thousands of cases. So it's amazing that, I always get amazed when one screws up and you're like, only one. Oh, wow. Okay.
Yeah, I just want to make sure it's right in the books, and
that's all we try to do. That's what I found out for you is that's where the rubber meets the road. Contact that. All right.
All right. IT service desk at kentcounty.mi.gov. Okay.
Yes. Take care, sir. Have a good morning. Good luck, everybody.
Thank you.
Thanks for being here. Carly, any questions? Okay.
No, I'm just going along for the ride.
No problem. Well, that's all I'm doing. I go along for the ride and try to get people through this stuff. So I just get the enjoyment of hearing people's stories. So
appreciate you and
appreciate you. You take care. Have a good morning, ladies and gentlemen. Take care. All right. Next. Welcome. We are here in the matter of Lewis versus Dukes, case number 20-09073 DP. This is Mr. Dukes. This is your motion. It appears that there is no court-ordered parenting time. It is by agreement of the parties, and there doesn't seem to be an ability to agree at this time. Does that pretty much sum it up?
Yes.
Okay. Ms. Lewis, I did not receive a response from you. Is there anything you'd like to say?
No.
Okay. All righty. At this point in time, either party has the right to ask at any time for specific parenting time when there is none. The idea is that, you want specific because then the child knows when the child is going to be going certain places, doing certain things with certain people. So that the child gets on a schedule and so do both of you. You know then when things are going to happen up front so that way you can make plans. Right now, there is nothing like that. So the law indicates that I need to get you some specific parenting time. So I'm going to send this to the front of the court. I've reviewed both of your incomes. And I know state aid is involved here, so the fees will be waived on this. So I will send it to the front of the court for a parenting time review. Any questions? What they're going to do is they're going to meet with you. What you guys need to sit down with is they're going to need to know when the child's available. So what is the child's schedule? They're going to need to know when your work schedules are so they know when you're available.
Yes, we already had this in place. I think now he's just taking it to court to get it court ordered. But we already
Okay.
had this in place
Oh,
a
if you
long
got
time for now.
yeah, if you
now.
have an agreement in that you want to put in writing, you can make it into a court order.
Clearly, that's what this is. I'm
Okay.
going to guess from his end.
We don't
Right.
have anything.
All right. In that case, I'm going to send this to the front of the court. Again, have your current schedules available so that they know when the child and you are both available at the same time. Okay.
Okay.
All righty. Take care of yourselves. Good luck.
Thank you.
All righty. Have a good morning.
You too. Bye-bye.
Good morning, ma'am. How are
Good
you?
morning.
Welcome.
I'm good. How are you?
So far, so good. Is that the child?
Oh, yeah, one of them.
I can't have them in, they shouldn't be in court because
Sorry.
technically we're in court. That's okay. If you don't mind, see if we can.
Come on. Is it okay if I call my neighbor really quick and see if she'll
Well,
take
I'll
them?
tell you what, just keep her off camera, okay?
Okay. I tried to put them in the room, but then they were crying.
Yeah, I understood.
Sorry.
No, don't apologize. Taking care of children is what this court should be grateful for, and I am. So, in any event, let's go in the matter of Krupp versus Bryce, case number 24-02619DS. As to sole legal and sole physical custody, you've already been granted that, but you just need an order that says it's more specifically, because the prosecutor's orders are not as specific as they should be. So I'm going to grant you your motion to have sole legal and sole physical custody.
Thank you.
Now the question is, how involved has he ever been?
After Luca, the youngest one, was born, well, actually, since Leilani, the firstborn, he stopped coming around when she was 5 months when I broke up with him because he said if we're not together, that's not his daughter.
Is it his daughter biologically?
Yeah.
Okay.
But he has a thing against white people now, I guess, and she's half white, so he disowned her.
All right. Well, wait. Okay, because that's the only child. No, we've got two children in this case, Leilani and Luca.
And then once Luca was born, he said,
well, hold on. I just asked, if he's been involved. The reason that I'm asking is because he's not here. This matter was set for hearing at 9:30. It's now 9:58. Because one of your requests is because of the underlying illness that the child is suffering from, which is genetic based, correct?
Yes.
And you're requesting that he assist by giving a DNA sample. Okay.
Yeah. But
I was asking how involved he was because how easy is it for us going to be to order something like that? Because I'm going to have to grant a hearing on the DNA. I can't just grant that at a motion.
It will not be easy. But since I sent it out a week after I sent the court paper out to him, he didn't confirm that he got it. But since I sent it out, they called and said they did receive his sample.
Oh, good.
So
good.
Yeah.
Don't that
took
hoop does
3 months of begging. It took doing this.
I was trying to figure out how legally I could jump through that hoop. I would need a hearing where he would have to request, where he, because this isn't about DNA to prove that this child is his. This is about DNA to show what genetic markers he may have for the illness for this child. Is the prognosis for Lucas good or?
gotten a lot better since he's been in therapies, all of them since he was 6 months old.
Right.
And he got his G-tube placed September last year. And then he was hospitalized like 2 months later for failure to thrive.
Okay, so he's doing
And then he
better.
got-
He's starting to do a little bit better.
Yeah, he's starting to get better.
Okay. Well, I'm glad that the DNA was given. That way it could assist this child in finding out what the better treatment availabilities will be. But because I note that when you need a specific order for the actual sole legal and sole physical custody you already have, that I'm going to grant that so that the hospital has an easier time helping you make decisions. And it's them that's indicating they need this. So, and I want to get this child treated as quickly and readily and easily as possible. Let's make this order more succinct. All righty.
Thank you so much.
Take care. Have a good morning. Good luck. Take care of the children. All righty,
Thank you so much. You too. Bye.
Motion granted. Trying to remember if this was Swahili or Kinyarwanda. Somalian. Okay. All righty. Ms. Bule, did you connect, ma'am?
Yes.
Okay, let's go on the record in the matter of Bule versus Muhammad, case number 20-00081 DM. Abdallah, please raise your right hand. Do you swear or affirm to translate from Somali to English and English to Somali to the best of your ability, sir?
Yes, I do, Your Honor.
We are here on the motion by Mr. Muhammad for entry of a front of the court recommendation.
Marka hadda maanta waxaa joognaa oo hadal Mr. Mohammed keensada oo maxkamadda hortiisa oo dhigay.
The recommendation has already entered as no one objected to it.
Marka hadday hadalkii asaga keensada jaa waa la geliyay meesha oo maxkamadda waa laga sheegay haddina qof oo dhahay ma jiro hadalka gadaal ma ku noqonayo ma jiro.
It became an order of the court on April 16th.
Marka bishii lixaad taariikh 16 bishii afraad taariikh 16 ayuu imaaday hadalkaas.
Miss Bule, did you receive a copy of this?
Miss Bule ma heshay warqadaas oo hadalkaas sheega? Yes.
Okay. All right. And Mr. Bule, I'm sorry, Mr. Muhammad, you received a copy of this.
Mr. Muhammad, adigana copy ma heshay?
Yes.
Okay. Does either of you have any questions? You need to comply with this order.
Marka labadiina qofkii su'aal qaba waxa waaye maxkamadda waa inuu dawraco la shaqeeyo waa.
Mr. Muhammad, yes?
Yes, and my ex-wife, she's refusing parenting time several times. She contempt the court order.
Okay. Mr. Abdallah, please.
Marka waxa waaye naagtii hore aan qabi jiray marka way diidaysaa wixii iyada maxkamaddu la gooyay wixii la gooyay meesha maxkamadda iyada maraaso.
Miss Bule, are you not complying with this order?
Miss Bule, maxaa sheekada maxkamadda u raaci waysa wixii haddaa la geliyay?
walaalkay waxaan dhahay aniga maxkamadda ma raaci waayo ilmahan iyagaa diidan ilmahana ilmo oo 13 jira uga yar ani ma garaacayo cunug ma baxayo dhahay soo bax waa ilaa ma dhaxayo ma garaaci kare waana u sheegay friend of court intaas mar u sheegay dheh.
Yeah, she's saying that I do complain. I'm not gonna refuse to complain with the court orders. But the kids, the youngest is 13 years old. And I am trying to encourage them to go to their dad, but they are the one who doesn't want to go.
Okay. They have to go. This is now a court order. You must tell them that. They don't have a choice about going to school. They don't have a choice about complying with court orders.
Waxa waay kan waa sheeka oo maxkamaddu ku soo baxay waa laazima inay tagaan waaye. U sheeg hata iskool haddii rabaan ha tegin laakiin meesha abocod waa inay tagaan waaye maxkamaddu sharcidooda waa.
Mr. Muhammad, if she does not comply with the order, you may apply through the current county front of court for a parenting time show cause.
Marka Mr. Muhammad maanta amara la siinaa haddii ilmihii ay ku imaan waaye iidan haddii ay raaci wayso maxkamaddu u weynki teg soo sheeg ina ilmaha waa lagu diiday.
It's easy.
Yeah, she's saying that it's okay. She can go to county to call.
laakiin ani cunug ma garaacay dhe inuu raaco wadankaana sharci ilmo ma la garaaca
Yeah, she's saying I'm not gonna fight or whoop the kids, in this country because you cannot touch a child.
Again, tell them this is a court order that they have to comply with as well.
sheekadan maxkamadda ayaa kusoo baxay marka waa inay raacaan waay. Yes, I told them and I will tell them.
And there may be consequences if they don't.
Haddii ayaka ay sameynin sheekadaas dhib ayaa u imaanaya.
Again, Mr. Muhammad, you may apply for a show cause hearing for contempt if she does not comply with the court order.
Marka sidaan ku dhahay Mr. Muhammad haddii iyada ay raay wayse sharciga waxa waay waa inaad tagto way maxkamad ugu weyn
sharciga marka asaga hadda sheegoy kan oo 9 ku imaanay 5 ka soo celinay miya dhe kaas ma la hirgeliyay dhe.
Which one? The child is there, one coming from 9 to 5 or?
Yes.
Whatever the court order says, yes.
Yeah, the last one was coming Saturday 9 a.m. to 5 p.m. Staying with in Grand Rapids area. That's what we agree, yeah. Because she refused before we agree to come Lansing and spend one night. So, and I'm flexible. So I'm not, khaki or, yeah. So, and instead,
Can you keep it to one sentence at a time, Mr. Muhammad, so that the interpreter can keep up? Thank you.
Waa wiilkii kaas waay unugii kaas waay oo sagaalkii la qaadaa ila 12 waxa waa xadaaytay asaga wuu doonaya in Lansing area uu imaado unugii hal haween in la socdo adoo waadiida oo kale laakiin haddana waxasdan asaga maraacay wuxuu doonaya sheekadii hadda maxkamaday soo gooyeen intaas uu raacaya sagaalkii subaxnimo ila 12 galabnimo unugiis waa inuu arko waay inuu la soo baashalo waaye.
Okay, if you have a current court order, follow it.
Marka haddii sharciga qabta lagu sameeyo waa inaa raacdo waay.
Waxaa ku dhahe waa raacade laakiin asaga ha raacde meeshii 5 ani 5 meeshii la iskugu keena ilmaha waa u geynaa subaxiina waa u geynaa 5 ha ku soo celiya meesha dhe ani hal saa haddii ku darsada anigana dacwo lay bilaawa dhe markayga u sheeg.
Yeah, she's saying that I will follow the court order and as he stated in the court order saying that 9 a.m. I have to take the child where he is, where we meet, and 5 he has to bring back at 5. If he had 1 hour, then I'll comply to. I'll just put another.
Both of you need to comply with the order as written. You don't get to play with it.
How why? Sharciga waa inaad raacdo waay. Alla ciyaarin sheekada.
Waa diyaar waay.
Yeah,
Okay,
I will start. I will come tomorrow morning, and the place is a Grand Rapids police station in front of Grand Rapids police station, 9 a.m. So I will return the same place at 5 p.m. and tomorrow.
Wuxuu dhahay aniga sidii sharciga waa inaan raaco waay. Sagaalka subaxnimo police stationka ayaan isku imaanayna unugi meeshaasaan ka qaadaya waa la tegi 12 galabnimana meeshaas ayaan ku celinaya.
Okay, have a good morning, everybody.
Markaas wax wanaagsan qof kasto. Thank you, Anna. May I leave you, Anna?
Oh, you may certainly do so. Thank you for your patience, Mr. Abdallah. Thank you.
Thank you. Yeah.
Glad he stuck around so that we can try to get mom.
Yeah.
I always worry about what is actually interpreted and said. Anyway, who's next?